live.
All right, we are back in Senate Judiciary. It is still February 24th. We have SLU 22 in front of us, which got sent over from Government Operations. And we have Rick from Legislative Council to provide us a walkthrough. I know it's 36 pages. I'm not sure if we're going to be able to get through it all in half an hour, but we'll take it as we go.
Yeah. So good morning, Rick Stengel, Office of Legislative Council, and as the chair said, it is 36 pages, but a lot of this is repetitive, which is helpful to the number of pages. I do want to kind of start with a bit of an overview of the bill because it is so many pages. What the bill would do, as written, is basically remove the power of not just corporations, but business organizations in the state from spending money in election activities. And that is defined. I'll go over that here in a little bit. So that's kind of the big overview. And that sounds pretty simple, right? It's a very simple idea that you, as the government, you remove this authority that a state has given for business organizations to do X, in this case, spend money in elections, and you remove that authority. So while that sounds simple, there are definitely some constitutional implications to be discussed. Obviously not going to get to all those today in 30 minutes, but my office will gladly provide testimony on that. And you should also have more testimony from interested witnesses who may be affected by this bill. It's a novel concept. No state has actually enacted language like this. You've probably heard of limitations on abilities of corporations, other entities from spending money in elections, and those have been litigated. Citizens United is the more famous Supreme Court case in recent history, but this is the idea is common, but the way that this would do it is novel, that you basically remove the power that corporations have to make those donations, if that makes sense. So that's kind of the background, and the reason that we're going to look at 36 pages is because Vermont specifically has our businesses scattered through several titles. This normally would be like a 5-6 page bill because the language is very repetitive, but because you have corporations in 11B or 11A, nonprofits in 11B, LLCs in 11, this bill makes sure that there's no loophole, that no business can be created just to spend money in election activity. So therefore you have this very repetitive language in every possible business and statute. Okay. So start the walkthrough, if that's okay with the chair. Page 1 starts with the findings and purpose of the bill. I'm going to skip to subsection D. You can read the findings there on your own. Subsection D, the purposes are to revoke any prior grants of powers to artificial legal persons that may be construed to authorize election activity or ballot issue activity. Those terms are going to be defined here in a little bit. Re-grant only those powers necessary or convenient for lawful business, charitable, cooperative, or organizational purposes, expressly excluding any authority to engage in election activity or ballot issue activity. On the top of page 3, establish uniform limitations across all entity forms while preserving distinctions among them. And 4, preserve and protect the constitutional rights of natural persons and the lawful activities of political committees and political parties. So again, these are just purpose statements, but again, setting the stage for how this bill is going to be structured does not affect people's ability to spend money. CEOs, anybody that is a human being would not be affected by the bill. It would be the business entities that would be affected by the bill. Section 2, there are 12 sections in the bill because we have these scattered chapters and titles regulating businesses. Section 2 amends Title 11, Section 42, which is very specific to private corporations that operate as a regional clearinghouse or a cooperative loan plans. These are a very specific set of businesses, but because they would be they could make these contributions, as they currently do, are able to do so. There's language added to amend the authority of these corporations. In subdivision A on line 14, you'll see some language added, and this varies by statute. Sometimes Vermont has given corporations the power to do anything that an individual can do, and then the language needs to be adjusted to make clear that it's not everything. So in this case, we have, as limited by this section, private corporations have the following powers. And I'm going to skip to page 5 because any changes on pages 4 and the top of page 5 are just grammatical. On line 13 on page 5, a corporation organized pursuant to this chapter possesses no power to engage in election activity or ballot issue activity, and any such activity is ultra vires. I have to think about that word because we pronounce that virus in Texas, so I have to be, but still I have that blood in my body. It's voir dire, not voir dire. So ultra vires and void. As used in the section, these are definitions that are going to be repeated throughout the...
I'm sorry,
yeah.
Can you just give me a quick definition of ultra vires?
Outside the power of the organization. So wrongful activity. In other words, typically it's used in corporations where shareholders can basically sue the corporation for an act that the shareholders believe is outside the scope of the power of the corporation.
Thank you.
Mm-hmm. So ballot issue activity means paying, contributing, or expending money or anything of value to support or oppose any initiative, referendum, recall, constitutional amendment, charter amendment, or any other question formally certified or submitted to the electors of the state or any of its political subdivisions. So every time this definition is used, it's going to have these exact same words. So I'm going to skip it going forward, but again, this is one of the things that over and over again, you're going to see businesses are not going to be able to do. Paying, contributing, spending money, or anything of value to support or oppose any initiative, referendum, recall, constitutional amendment, charter amendment, or any other question formally certified. It does not include, on the top of page 6, any bona fide news story, commentary, or editorial distributed through an independent news organization not owned or controlled by a political party, political committee, or candidate. The determination by a corporation to endorse a ballot question and the de minimis use of resources of the corporation to communicate the endorsement to the general public. 3, activity by a corporation to support or oppose consideration of a measure by the General Assembly or by a legislative body of a political subdivision of the state prior to the formal submission or certification of the measure to the electors. Lobbying is how I would define that section. Lobbying activities would be exempt from this. BI. Election activity means paying, contributing, or expending money or anything of value to support or oppose a candidate, political party, or election activity does not include similar language, bona fide news story, commentary, editorial, not owned or controlled by a political party, committee, or candidate. The determination by a corporation to endorse a candidate and the de minimis use of corporate resources to communicate that endorsement to the general public, provided the endorsement is not facilitated, solicited, or approved by the candidate or the candidate's committee.
So does that just mean no donations as well?
It would include that, correct?
Okay, and then back up a little bit on ballot issue. It talks about where'd it go? But I'm thinking of like a business that is a print shop.
Right.
Would that fall into here? Because if you were hired to print the media or postcard or whatever it is, would that fall into here? Because technically you are contributing as you're contracted to do so.
So would a print shop doing that, would that be supporting or opposing any candidate referendum?
It could appear to be.
Potentially.
You print it,
You
right?
could choose not to take the business.
Right.
You could choose not to do the order for the company. So that may need to be thought about. Yeah.
Rick, one question also on page 6. So ballot issue activity does not include activity by a corporation to support or oppose consideration of a measure by the General Assembly. I'm kind of thinking of what we think of as issue ads and candidate ads. So a corporation under this not only could hire a lobbyist, but they could run ads saying the General Assembly is thinking about raising your taxes, and they could spend whatever they can spend currently, but they can't, in the election itself, spend money.
That's, I think, a good read of the language, that not only can you spend money on lobbying, members of the General Assembly, that if there was some kind of issue that a corporation wanted to spend money to advertise either on Facebook or on
Yep.
TV, that would also fall under that exception.
And so maybe over here on page 7, it has the Secretary of State adopting rules to clarify things, including setting parameters. Might that include timelines from an election? Like within so many days of an election, you can't?
It's so, yeah, I hadn't got that sentence yet, but that's a big one. On page 7, subdivision 5, the Secretary of State shall have the authority to adopt rules regarding the definitions of terms set forth in subdivision 4, which includes the ballot activity, election activity. So, yes, it's very broad authority. And there is a specific rule authority there about parameters of what is and what is not considered de minimis. But I think the Secretary of State would read this and say we can also provide authority on, running elections during a General Assembly issue that is being taken up.
Okay, thank you.
Now, does that include like an election activity, like your scorecards, report cards? We'll get the email, this vote might be on your report card or scorecard, whatever it is.
Who do those come from?
Advocacy groups.
Yeah, I'll pick on ones in the room.
League of Women Voters.
Yeah.
We don't recommend candidates.
Oh, but don't you have scorecards? No?
Have scorecards. No.
Honestly.
You'll
So expending money, does it cost money to create those emails?
Imagine.
De minimis.
I don't know.
It's up to certain
I guess so. Okay. I'm just curious what.
You're giving the
It's a
Secretary
very-
of State a lot of authority.
Yeah, it's very broad, so I'm curious what it.
Okay. Section 3. This is specific to financial institutions and mutual insurance companies. We're still in Title 11, skipping to page 8. So one of these corporations possesses no power, on line 4, to engage in election activity or ballot issue activity, and any such activity is altered by reason void. I'm not going to repeat, these are the exact same definitions, starting on line 6 on page 8. Nothing changes on those two definitions. On the next page, 9, also, nothing on this page is new. This is repetitive from the previous definition of election activity and the same rulemaking authority for the Secretary of State. Okay, on page 10, this statute in Title 11 governs cooperative associations. You're going to see very similar language again. And again, I mentioned this earlier, but occasionally the way these businesses are given powers, you see here section 994 powers, they're written differently, and in order to get the purpose of the bill across these various businesses, you have to write the exceptions differently. So on line 14, you see here, and let me start with line at the very top, on line 6 of subdivision 10, to do everything necessary, suitable, or proper for the accomplishment of any of the purposes or the attainment of any of the objects herein enumerated, or conducive, etc., to exercise and possess all powers, rights, etc. Then skipping down to line 14, and to the extent consistent with the artificial person powers defined in subsection E of the section. So that, not removing language there, but saying that you have every power except this exception. B, a cooperative association organized pursuant to this chapter has artificial person powers and only the powers expressly granted elsewhere in this chapter. On page 11, subsection C is new language. The creation and continued existence of a cooperative association organized pursuant to this chapter is a conditional grant of legal status by the state and remains subject to revocation or alteration at any time. You'll see this occasionally where the state has given itself the authority to revoke the authority of in this case, cooperative association to be existent in the state. D is repeated language about ultra vires and void activity. Subsection E, there is a new definition, artificial person powers, because it's used in this statute. It means the powers necessary or convenient to lawful cooperative association purposes, excluding any authority to engage in election activity or ballot issue activity. The definition of ballot issue activity is the same as is election activity. And subsection F on the top of page 13 gives the Secretary of State the same rulemaking authority. Section 5 is the Worker Cooperative Corporations chapter in Title 11. So in this case, the power section is created to establish and put parameters around the powers of these corporations. Subsection A is similar language that it is governed by this chapter and is a conditional grant of legal status by the state and remains subject to revocation or alteration at any time. Again, these corporations has only artificial person powers. Same definitions in subsection D.
Are we on 16?
Page 16?
Yeah.
I'm almost there.
Okay.
Yep, starting at the bottom of page 15.
Got it.
So section 6, these are the LLCs, a very popular form of business in most states, including Vermont. Here you have language struck through, and I'm going to read this because this is existing language that would be important to LLC owners and operators. An LLC, limited liability company, shall possess and may exercise all the powers and privileges granted by this chapter, any other law, its articles of organization, or its operating agreement, together with any powers incidental thereto, so far as the powers and privileges are necessary or convenient to the conduct, promotion, or attainment of the business purpose or activities of the limited liability company, including the power to sue and be sued, complain and defend in its company's name, and, most importantly, the power to do all things necessary or convenient to carry on its activities, which, again, in modern business organization statutes, that's what you're going to see. States have overwhelmingly decided to give LLCs, corporations, the authority to do anything. That's very, very common. Vermont's no different. But that's been struck through, and instead you have the creation and continued existence of a LLC governed by the chapter. It is a conditional grant of legal status by the state and remains subject to revocation or alteration at any time. An LLC has only artificial person powers, similar language there. Jumping down to 4, a limited liability company that undertakes, finances, or directs election activity or ballot issue activity without authority pursuant to this chapter shall be required to remit payment to the office of the state treasurer of an amount equal to the value expended in the activity. You'll see that. Yep.
I had a question about that. Is that taken from elsewhere in terms of what the penalty is? So 100% of their unauthorized spending or ultra vires spending is their penalty? Is that a new construct, or is that a penalty that exists elsewhere?
In the state or anywhere?
Here.
Personally, I've not seen this language used. Doesn't mean it doesn't have precedent, but I have not seen it. I can look into that.
Because it's interesting. It reminds me of the excess spending penalty.
Right.
In other words, an LLC, and correct me if I'm wrong, could spend $1 million on an election and then pay a $1 million penalty to the Secretary of State.
Correct.
Okay, so it says that their LLC status can be revoked or altered at any time, but it doesn't clarify that if they do that, it will be revoked.
Correct.
So it's basically just setting it up as a steep penalty, 100% penalty.
Correct.
Okay, not wild about that, but anyway.
Okay, subdivision 5. A foreign limited liability company, meaning an LLC that's organized outside of the state, not outside the country. Although I guess it could be, but this is mostly referring to an out-of-state LLC that directly or indirectly undertakes, finances, or directs election activity or ballot issue activity in this state, or with respect to any election or ballot measure submitted to the elections of the state, is conclusively deemed to be transacted business in the state for jurisdiction and enforcement purposes. So if you have an outside LLC in New Hampshire, New York, that wants to spend money on a Vermont election, even though they may not even be organized in Vermont, they would be subject, based on this language, they would be subject to remitting payments to the Office of State Treasurer.
So is this getting, you know, so is this kind of closing the door to any disagreement about personal jurisdiction?
The words on the paper make it sound very simple, that this is just the way that it's going to be, but I assure you, there are constitutional issues with requiring an out-of-state business to not exercise one of its constitutional rights in Vermont. So personal jurisdiction is interesting. They would be availing themselves of the state by conducting business in the state. So I'm not sure that would be an issue, but there are certainly other constitutional things that may come up.
Yeah, I mean, it might be a stretch. I'm just thinking of the indirect participation, but and, you know, if it's indirect, you're going through multiple states.
Right, I see what you mean, yeah. It could be a very, very indirect business being conducted in Vermont. I see what you mean.
And so it's just the conclusively deemed piece is what makes me wonder if that kind of shuts the door on any personal jurisdiction question, but that sounds like that might be a different issue.
I think it's a different issue,
On top
yeah.
of the other one.
Subsection H, same definitions. So we will jump to page 19, still in Title 11. These are your limited partnerships. A and B and C are similar definitions you've seen before about ultra-vires and remitting payments to the Office of State Treasurer. D is different language because partnerships are unique in different ways. The liability provisions set forth in subsection B of the section apply to limited partnerships and to all general partners, limited partners, and other persons of the limited partnership who authorize, direct, control, or knowingly participate in such activity. E is also different or new. This section applies only to limited partnerships and does not apply to general partnerships or other associations in which all partners bear unlimited personal liability for the obligations of the partnership. Subsection F, the definitions are the same. I'll keep saying it every time.
I assume at some point you'll address the overall constitutional question?
Yeah, we'll see. You know, it's almost, we have about 10 minutes left. If not today, certainly.
I'm just hoping today you can give us some sense before we leave, because if it's mooted by the Supreme Court, not that I don't think this is a useful exercise, but it'd be good to know what our chances are in terms of the supremacy clause.
So we can see,
If much of the rest of the bill is going to be kind of repetitive just to get to the other chapters of all the different forms of businesses, then I have no problem with getting the spark notes of what your initial concerns are, and then scheduling another hearing a bit later on so we can take a deeper dive into it.
sure, I do want to show, so most of the language is repetitive. I will note that the most probably the sections you want to look at, language similar, is going to be on page 25, section 9. That's your business corporations, Title 11A. And then the next section, section 10, on page 28, that's your nonprofit corporations, chapter 11B, Title 11B. Those are going to be the most common types of entities that will be affected by the bill. So again, the language is similar, but if you want to look at especially the struck out language to see what the state would be doing to those entities would be, I think, helpful to understand the bill. And then I do want to walk through the last page, section 12, the applicability of the corporate power reset. So page 36. Nothing in the act shall invalidate, impair, or modify any contract, debt, instrument, security, or other legal obligation lawfully entered into on or before December 31st, 2026. The effective date would be January 1, 2027. That's why you have the December 31st date. No power, privilege, or capacity withheld or limited by the act shall be revived, reinstated, or implied by operation of law or judicial construction. If any provision of the act is held invalid as applied to any artificial legal person, the invalidity shall not be construed to authorize that entity to engage in election activity or ballot issue activity or to revive any power, privilege, or capacity withheld by the act. So just kind of making it clear that there is this kind of line in the sand on December 31st of this year that is basically saying that this applies starting January 1, that you can continue doing these election activities, but starting, even if you're in existence today, a corporation existing today would be held to these new statutes starting January 1, 2027. Okay, so the question is about, and I have two of my colleagues here who we've all been working. This is a very interesting bill because even though the corporations are in my portfolio, Tucker deals with the Vermont Constitution and corporation charters, municipal charters, which have some relevance here, and then Tim, elections. So the three of us have been working on this bill, and we're here to answer questions. And you said you want you said Cliff Notes?
Spark Notes or Cliff.
Spark Notes.
Whichever one.
Very 21st century.
Just a general synopsis,
Yeah.
initial take of what the constitutional concerns are, so that we have them in our heads, and then we can have an additional hearing
Yeah.
at another date, so we can take a deeper dive and see what is feasible or not.
Yeah. So I referenced a little bit, I referenced Citizens United, which I think you are familiar with, especially Senator Norris with his work on the Government Operations Committee. The idea is novel, right? The idea of removing a corporate power to spend money in elections has not been enacted anywhere. So that's a novel concept. And with that said, you have a lot of court precedent that kind of gets to this issue of a state regulating a corporate's authority to do something. There's no doubt that the state does have an authority to control corporations in many ways, and you can see in the statutes, you have, typically Vermont has given corporations the authority to do anything, and that is the decision that Vermont has made. But the question is, can then a state take away powers? Can a state then restrict powers? In this case, the argument is that are these First Amendment powers, the freedom to spend money in elections, is that a power protected by the First Amendment? That answer is mostly yes. That Citizens United and other similar decisions have said that corporations do have a First Amendment right to spend money in elections. You can disagree with the decision, and maybe at some point the court will change their mind, but our job is to kind of inform you of what a court is going to look at. And that's going to be case number one, right? And Bellotti is another Supreme Court case. Similar holding that corporations have these rights. So that the Spark Notes is a complex set of topics. It's not just the First Amendment, it's also the Contracts Clause, because you'd be regulating corporations that are already chartered in the state. There's due process involved here. There is 10th Amendment involved here, and it's the word complex is the first word I keep thinking about, and deserves a lot of thought and witnesses to kind of help you through this bill and how you want to accomplish your goals.
Just to refresh my memory, Contracts Clause, that's when the state makes a law that affects already existing contracts to the benefit of the state.
It doesn't have to be for the benefit of the state, just a pre-existing contract, right? Yeah. Now it doesn't mean you can't ever do that, but that's something that you want to look at and see, look at the court precedent and see when can states not do this. what are the limitations on that? I mean, can states do it?
And Senator Booth.
I'm just remembering the popular way of phrasing Citizens United was that corporations are people, they have First Amendment rights that cannot be, they're inalienable. So when I read this, I agree 100% with our ability to do this and with the world it would produce, but it seems to me that a majority on the Supreme Court believe that corporations are people with constitutional rights that cannot be revoked because they're fully Citizens United, right? Am I wrong to think that there's just an insurmountable bar at the Supreme Court in terms of a 6-3 majority or 5-4 majority? Not that you can read the future, but
Right.
Do you see what I'm saying?
I do, and I may defer to Tucker as well, but I think, and Tim as well, and I think my answer to that is it's not just the current court. There's been decades, maybe over a century, of court decisions that have kind of led to Citizens United, that corporations, not that they're people, right? That's what Citizens said, but that corporations, while they are creatures of the state, because you get a charter from the state, they also have these rights. I don't know if I use inalienable, but rights that are inherently theirs, that the government cannot give or take away. So if the government cannot give a right to something, can it then take it away? So yeah, I don't know if I would look at this court and say this is what they're going to do, but I think you look at the history of the court's decision on corporate rights, and you say this is probably what a court in the next few years would do, because this is the precedent, and these are the decisions that have led them to citizens.
So maybe I'm oversimplifying this, but in other words, the First Amendment isn't a right that is given to corporations by the state. It's enshrined in the U.S. Constitution, and we can't circumvent or curtail that right. Is that kind of conclusion?
Tucker?
To frame all this, Tucker Anderson, Legislative Counsel. Since the beginning of the 19th century, there's been a string of U.S. Supreme Court cases identifying corporate personhood. And really what Senator Baruch was talking about is a railroad tax case. It's literally called a series of railroad tax cases decided by Chief Justice Shaw, starting in 1881, in which they identified that the corporation is an artificial person, specifically capable of holding rights under the 14th Amendment to the United States Constitution, including due process and access to the federal courts. And since that time, the United States Supreme Court has started to identify all of the rights that a corporation is capable of holding as a person. Now, that does not mean they are entitled to all of the rights that are identified in the guarantees of the United States Constitution. But the United States Supreme Court has identified specific instances where there are constitutional rights that are held by corporate persons. And there are 2 United States Supreme Court cases that apply to the bill in its instant context. The first was decided in 1978 in its first National Bank of Boston versus Bellotti, which identified that corporations have First Amendment rights. The second is Citizens United. What you have in front of you is very interesting and nuanced in its approach, but that approach is still constrained by the guarantees of the federal Constitution, and Rick has not gotten to this yet. We're happy to inform you about this, the Vermont Constitution, because that is the well of power that you are drawing from. And the Vermont Constitution is unique in that it identifies specific limitations on the General Assembly and its exercise of power over corporations. That's Section 69 of the Vermont Constitution. It has a direct impact on the legal analysis of the bill in front of you. And as Rick said, it is an endlessly complex and interesting topic to go through. We have prepared a ton of research on this, and we're always happy to come back and walk you through. It gets confusing very fast because you have to start with U.S. Supreme Court decisions in the 19th century that predate Vermont's adoption of Section 69, and then continuing through into the modern era in the U.S. Supreme Court's decisions about First Amendment rights of corporations. And thank you for the ability to provide that context.
Well, we are right at noon. Thank you for the walkthrough, and